Patricia Van Haren, family law attorney and mediator, and the author of How to File and Survive a Divorce in California. Many people wonder what happens when they have issues after the end of the divorce. Well, the final judgment is the end of the divorce process. There are times where the parties continue to litigate matters after the time that the divorce is completed. Or there may be times that parties choose to come back to mediation or re-enter the collaborative process. Although the intention of a judgment is long-term, it still can be modifiable with the showing of a significant change in circumstances. These are called modification motions, which, if you're in litigation, they require the filing of a request for order. Fortunately, mediation can allow adjustments to various orders without the need to have a judge weigh in on your changes. Frequently, the parties continue to have problems in the co-parenting relationship, and they require court intervention to make new orders in regards to child custody. In most cases, once a final judgment has been entered, the party who wants to make the change must show that there are changes in circumstance when it comes to child custody and visitation. For example, a parent may move away, or they may not be exercising their appropriate visitation time. Prior to filing a case with the court, you may wish to seek out a collaborative attorney or mediator so that you and your spouse can work together on changes in the parenting plan. This process may also assist you in moving past some of the communication issues that arose during your divorce case. Also, the income of one of the parties may change, or one spouse may lose their job. The orders continue to remain in place until they're replaced with a new order. Therefore, one party may need to request a modification of either spousal support or child support. Many final judgments contain an order that a spouse is to become self-supporting in a reasonable time. Therefore, years after the divorce is finalized, the supporting spouse may seek a modification or termination of spousal support so that they can have financial freedom from their former spouse. Child support is modifiable up until the child is 18 years old and has graduated from high school. We work with parties to assist them in coming to agreements on child support and spousal support modifications. We are then able to prepare a stipulation, which will get filed in the court. What constitutes a change of circumstances depends upon the facts of your case. Further, there are many ways in which you can request to change these orders. When a couple is able to communicate, it may mean that an additional mediation can resolve these issues. Or there may be cases where utilizing the collaborative process will assist both the parties in resolving these issues. In cases where parties are not able to come to an agreement on any changes to the orders, then the court will need to make a determination as to whether it's appropriate to modify the existing court order. As the burden of proof is on the moving party, it is important that you gather your evidence prior to filing any motions with the court. Discovery will reopen when the hearing is filed. A post-judgment court action can be just as costly as litigation during the divorce process. Therefore, you should always explore alternatives such as mediation or the collaborative process first. If you have any questions regarding post-judgment issues, please don't hesitate to shoot us over an email or give us a call. We look forward to hearing from you.